Welcome to preparing for your trust account audit. Your number is going to come up sooner rather than later, and at some point the Office of Attorney Ethics is going to send you a communication saying that they need to audit your books and records. All right, perfectly normal thing to do, but it's a little bit of a daunting challenge. So the seminar we're going to be talking about today deals with all types of trust accounting procedures and the steps you should be taking when and if you are subject to an audit in the future. My co-presenter today, the one and only, and I do mean only, William A. Zarling, former Deputy First Assistant Prosecutor, right? 36 years with the Prosecutor's Office?
Every minute of it.
All right. And Supreme Court Committee on Character?
So they tell me.
And Senior Instructor with Garden State CLE?
Definitely.
All right. Here we go. I want to start off with speaking about, first of all, just some introductory issues relative to trust accounting in New Jersey. First of all, everyone should understand that the New Jersey Constitution is what really provides the ability of the court to get involved in this in the first place. This is the main section. Court shall make rules governing the administration of all the courts in the state and, subject to the law, the practice and procedure in such courts. The Supreme Court shall have jurisdiction over the admission of practice law and the discipline of persons so admitted. So, if you go back to the first sentence where it talks about the practice and procedure in all such courts, this is the grant of authority that allows our Supreme Court to promulgate the rules of court. And the main rules we're going to be talking about tonight are set forth in Rule 1:21-6, together with the rules of professional responsibility, and specifically we're going to be talking about RPC 1:15. So, when it comes to trust account issues, one court rule, one RPC, and then an enormous volume of case law, body of case law that's developed over the years, the most important ones beginning in 1979. I want everybody to understand about, in terms of the numbers of attorneys we're talking about and the challenges in terms of audits. Take a look at this. Total number of attorneys admitted to practice in 2008, which is the most recent year I could get figures for, 85,000, all right, eighth highest in the United States. Engaged in private practice, 34,381, which is about 40%. 90% of those practice in New Jersey. 21,000 full-time attorneys, 7,300 part-timers, occasional attorneys, 4,570, and undefined, those are the ones you got to watch out for, 1,155. Law firm structures, sole proprietors, by far the biggest, 11,068. Smaller firms, 2 people is 3,400, 3 to 5, 5,200. Then the bigger firms, 6 to 49 seems to be the main size, 9,300 of them, and then 50 or more attorneys. There were 5,000 of them. What you're going to find for issues that come up with respect to trust account and trust account auditing, almost all of them are going to be involved with the sole proprietor and 2-person firms for the most part. All right. Grounds for discipline. These are the main areas where attorneys were subject to disciplinary action by the Supreme Court during that time of year. Vast majority of accounting issues arise in the context of sole practitioners or small firms, 1 or 2 people, and the reasons for that should be fairly self-evident. You know, you've got sole practitioners that have to do everything themselves. Lots of times they will either put the trust accounting responsibilities off to the side or not have the skill set in the first place to keep those books and records. Gross neglect and pattern of neglect accounted for 28% of the final discipline. Gross neglect typically is going to be letting statutes of limitations run out. Pattern of neglect is going to be more than one incident involving neglect of a client or a client's business. 20% of the cases involved either negligent or reckless misappropriation of entrusted funds, meaning that there was a misappropriation of entrusted funds out of a trust account, for example, but it wasn't done purposefully, but rather it was as a result of either negligence or recklessness by the responsible attorney. 16% of the people, 16.5%, were disciplined as a result of the knowing misappropriation of entrusted funds, and that has special rules associated with it. Interestingly, I don't know that anybody would really know the answer to this if I'd asked them, just people off the street. $3 billion held in New Jersey trust accounts, and that doesn't include additional sums that are held for estates and guardianships and things of that nature, which have their own separate accounts and are not typically shared trust accounts. In other words, you have multiple clients all in the same account. All right. The purpose of the audit program there's multiple reasons for conducting it. There's an enormous educational component, and you should understand, and you'll see from the statistics, 98.7% of the audits are unremarkable. I mean, just the people are doing okay. They're complying with the rules. Nothing will happen to them. It just pass right through. So it's a very small percentage that actually wind up triggering some type of a disciplinary action. Typically, notice is provided anywhere from 10 days to 2 weeks ahead of time, so you'll get notice from the Office of Attorney Ethics that you're going to be subject to an audit. The review is always going to be both of the attorney's business account and the trust account, although in our course this evening we're going to focus primarily on the trust account. You'll be receiving education in terms of the maintenance of the records, where the records have to be kept. They'll be checking on who the signatories on the account are, and of course that has to be an attorney at law in the state of New Jersey. They'll be discussing issues such as restrictions on the account. For example, you can't have an ATM associated with it where you can take money out, or you're not allowed to have overdraft protection on your trust account. One of the things that's not on here, but you can't have a debit card either, associated with your trust account. And like all attorney records in New Jersey, there's a 7-year retention period with respect to trust account records. So theoretically, you're responsible for having records to allow them to go back for a period of 7 years. Here are the basic purposes of the random audit. Again, it says it's intended to halt Ponzi schemes, and I'm not sure what they mean by reluctant clients, but I'll tell you about Ponzi schemes because I was actually the victim of one of these, where the attorney was, he had a very, very big gambling problem, and what he would do is he would take money in from a real estate closing and take it to Atlantic City and lose it, and then he would be paying off the mortgages and the other financial responsibilities from the next mortgage that came, the next settlement that came in. So he was always running 2 or 3 settlements behind, and eventually he got caught, because he ran out of money. But that's the type of thing that would get picked up in a random audit. And that's one of the purposes. Okay. There's educational components also training you about keeping separate trust ledgers for every client, for keeping a running balance in your trust ledger. Trial balance of trust ledgers to bank balances. All transactions must be recorded within 24 hours. These are all the educational components. No commingling of personal funds with trust money. No commingling of payroll taxes. By the way, when we say trustee taxes here, that is a term of art. It's a little bit counterintuitive, but I want you to understand when I talk about trustee taxes, I'm talking about monies that are payroll deductions taken out of employees' paychecks, which are you're holding on behalf of some governmental agency, be it federal or state. It's a trustee tax. You're a trustee holding it on behalf of the government, although ironically you're not allowed to put it into your attorney trust account. All right? You'll also learn this evening about separate client ledgers for bank charges and making sure that you follow the bank's funds availability schedule, because if you don't, typically, even though your bookkeeping numbers might look right, you may still wind up bouncing checks, and you certainly don't want to do that when you're drawing checks out of your trust account. New Jersey maintains an overdraft notice, and basically what this means is as follows. If a bank in New Jersey wants to conduct business with New Jersey attorneys and hold money in the attorney's trust account, they have to agree to participate in an overdraft program so that in the event that you bounce a check out of your trust account, the bank is obligated to inform the Office of Attorney Ethics that this took place, and this allows the Office of Attorney Ethics then to get involved and find out what happened and see if they can rectify the situation, or at least train you so you take the necessary steps to make sure that it doesn't happen in the future. Many times the fact that you've bounced a check out of your trust account is nothing more than a bookkeeping error or not following the right procedures. On occasion, though, it is evidence of something much more serious, these Ponzi schemes being an example of that. All right? Over the 23 years of the program, which I think it's up to 25 years now, it's resulted in final discipline for 123 attorneys, of which 66 were disbarred. And almost invariably, those disbarments are going to be related to a knowing misappropriation of entrusted funds that you're going to hear about. Okay? Now, I mentioned a few months ago that the starting point for the development of modern trust account law is 1979 in terms of the case law developing. And it's very important that you understand the background here, how we got to where we are now, the basis for the procedures that are utilized by the Office of Attorney Ethics, and how the Supreme Court of New Jersey views all of these things.